Good morning, everyone. Welcome to It's a Crime. For those of you who don't know me, I'm Linda, and today we are doing a different kind of day for the Lori Vallow Daybell case. We are this much closer to getting justice for Charles Vallow. And yesterday, we ended off with the prosecution resting, which is actually even, I don't know, 3.5, 4 weeks earlier than we thought. Also, a day earlier than we thought when they thought it was going to be shorter, if that makes sense. Good morning, everybody. At the end of the day yesterday, after the prosecution rest, they said, we have sufficient, we believe we have what it takes basically to lay it all out. And Trina K said, we have evidence in texts. We showed that there was a handgun brought to the house the night before when Alex stayed there. He brought a handgun there, the number of shots, the statements of Lori taking Charles's phone, motive of money, and motive of having an affair. Now, they talked about closing arguments, which will be on Monday. And Trina says she estimates it's going to be about an hour. When the judge asked Lori how long it was going to take, Lori said, not that long. She said less than that. It was a little bit of a kerfuffle yesterday trying to figure out what's happening today, what's not happening today. They were giving all kinds of times. We know that Lori's at the courthouse already this morning, and then they talked about jury instructions going through it. So I don't even know the time they're starting. This is how crazy it is. So we're going to be together. We're going to watch it. I think it's in 13 minutes, and we'll see what happens. Lori has to make a decision, though, if she is going to speak, if she's going to bring any, all kinds of stuff. She just figured, I'm not sure. She at first said the defense rests, and then he says, are you sure you want to do that officially? And hang on, sorry, I don't want that dinging. We'll have to figure out officially if you want to do that or not. So she has time, but the judge says, you need to give me a heads up. Okay, Your Honor. So it's been very short. Some people feel like they need more from watching it. I feel like I wish there was a little more detail. Unfortunately, they couldn't bring in the body cam footage of Charles, which sucks. I know that's the law, although I was reading yesterday that there could be some circumstances where they do bring it in, but I don't think he met that criteria. So I played it yesterday. So we could feel like yesterday it works and that we brought it in. How about? But Lori, I mean, she did a pretty crappy job, in my opinion, of representing herself. It was obvious she wanted to divert the attention to what was true, of course, and talking about water and time and apple juice and dates. She's asking witnesses about the dates that they're not even on the stand for. Who gives a rat's you-know-what about how many dates Charles went on when we're talking to the detective about something completely different? And she tried to smear him. And at one point, Trina said, no, let me just pull this up in my messy handwriting. I have to write so fast when they talk. Yeah, she objected to relevance of all the types of questions she was, and she said the defendant's trying to smear the victim. And judge says, well, it doesn't matter whether Charles went out on dates or not. Amy says, I pray Shih Tzu Barbie does not testify. I really wanted yesterday, I really wanted her to lose it. Like, I wanted her to lose her SHIT in totality yesterday. That did not happen. Almost. She was getting there, but not quite. I really did want to see her do that. I think that would have been perfect, in my opinion. What else? Yeah. Aw, nice to see you. Everybody, please give the thumbs up. Thank you very much. So they went through all the text messages that were pertinent to the text exchange. I mentioned this yesterday, possibly even the day before, depending on when we heard it, because the days are running in together. And I wish Trina would have slowed a little bit down on the part where Lori said, we got rid of him. I wish that was happening. It didn't. She still said it, but it's the detail I want a little bit more. Janet, thank you so much for the super sticker. I really appreciate it. Thank you for being here and hanging out. Hi, neighbors. I love that you said that. I'm going to have to figure out how to pronounce that if you're wondering why I don't say it. I really don't know how to pronounce that, but I'm willing to learn. So if you want to do the phonetically to say it, I can. But thank you so much. I know you've been supporting me and coming in here and everyone hanging out today. Mel says, I found the shoes. Check your email. So the shoes in reference from Mel, thank you so much, is the shoes that we saw Lori walk into Walgreens when she said she didn't have any shoes. And that's why she went to Walgreens to go get it, because the ground was so hot. But yet she managed to drive barefoot and walk no problem for that. So she's a liar. I wish they would have said, Lori, do you know what perjury is? Okay, let me see. Mel. Pictures. We also had some weird things happen yesterday too. We'll talk about, oh, here we go. Oh no, that's the other one. Just might take me a second, guys. Here we go. Okay, here we go. Kind of looks like them, doesn't it? Sort of, kind of, the front. So that's what I showed yesterday morning when we started, or afternoon, whatever the heck, yesterday's video. Right in the beginning, we walked slow-mo with Lori's shoes and how she said she was barefoot, but she's full of it. So there's that. Crystal says, I really hope she testifies. Petunia says, actually, I'd love for her to take the stand. I want her to lose it. Shell Bell, so good to see you. I want her to testify. I think that is when she's going to lose it. Right at the end. We saw her escalate. Monday, she was quite calm. And the last 2 days, yesterday was amping up. I feel like it would have been just like, give it a little bit more. I wish Judge would be like, let's just continue on right now. We'll save lunch for a little bit. Now I'm just going to pull this to the stage so that I remember it's here and on. I wanted her to lose it in court, though. Reality with Krista Marie says, I think the jury is smart and they're going to see what a joke she's made of this and how she doesn't give two rats' ass about her husband. Yeah, she only calls her my husband when it's convenient for her, and then Charles and others. I think it was disturbing the last 2 weeks where she was talking about the crunch of when Charles was getting CPR, proper CPR, the crunch. And there was another thing she really wanted to know. Put in the comments for me just to remind me. There was something else. And it was just, It was just weird how she just wanted to dive in the details. That is where she reminds me of Chad Daybell. Because Chad, I've pointed out in my behavior videos before that he gets duper's delight. He enjoys it, especially when it came to Tylee. And that was in a preliminary that I pointed that out way, way, way back. But this, she was enjoying some of the details too. Sonia says prosecutor lacks dramatic flair. The closing is on Monday, and then we'll see what happens today. We don't even know what's happened overnight. Who knows? Diana says, I agree on we got rid of him. Hopefully she says it in her closing. I'm sure she'll, because when she'll bring it all together, that she will. The jury must be wondering why Tylee hasn't been called as a witness. They don't know it's never going to happen. Yeah, I mean, we is duh. Okay. I'm getting pronunciation. Okay, for those who are listening and not watching this, I'm sorry. I need to do a little bit better job of not just mid sentence go to another comment. Yes, Kimberly says body cam back at her house afterwards showed Tylee and her wearing the flip flops. Yes, and then they also talked about that in court. But when she left, Lizzie says I was just watching the spooky bit from last night. So for those of you who didn't see it, yesterday. Now I'm trying to remember at what point. So there was a point in the trial where you guys heard a scream, and I said, "Where was the scream?" and asked for the timestamp. And then after court was done yesterday, I went through it, and there was, in fact, what sounded like a scream, and I don't have any explanation for it. So I don't know what has happened since then, but we did play it, and we played earlier that day that a long time ago when I do Charles's videos, for some reason there's weird things that happen to my editing and also my filming, and also there's some weird sounds. So we went through that yesterday. Anything else that happened? Basically, Lori got mad at why there wasn't more testing done on the bat. She got quite upset. But all in all, it's all a diversion because she's in trouble anyways. I mean, obviously, they have to do this and she's defending herself. But it makes her look worse because she created so many diversions and not even focusing at all on the text messages. Because typically, you have the prosecution come up, then they have cross, right? And then they do the others, but it's typically in line with what's going on. Well, Lori comes up and is way left field, just like her made up religion that she's created in her mind of what she thinks it is. And it's just like, where are we right now? Why are we talking about apple juice and bottles of water when we should be talking about what we've been listening to for 3 hours? Where you been? Where you been, Lori? Charlotte says, I thought they were starting again Monday. Monday is closing arguments, but they're meeting today in court, and it was supposed to be about jury instructions. That also changed 3-4 times. So we're here. We're going to hang out. We're going to figure out what's going on. Okay. I'm a little bit behind in reading your stuff, so I'm just going to pull bounced. Jen Bowling says, Linda, I'm happy to have you back and I apologize not being here sooner. Well, that's okay, Jen. Thank you so much. And thank you for being here. Thank you all for being here. Nate said no one screaming. So that's the weird thing. The detail is when she recalled it bouncing. Yeah, she's just brutal. Laura G says, Lori's so wishy-washy. Who knows about today? Every day's new, but Monday was particularly calm. It was a sneeze. Yeah, Rita says the text messages were to me she's toast. So tell me in the comments, what part do you think in trial sealed the deal for you? Even if you know all the information, what part in trial was like, okay, this is it? Charlotte says, was it something about bouncing? Yes, people are saying that. And I don't even remember what the full sentence was. Andrew says, I slept with the lights on. So did I. I did. It's going to leave a little bit of a light on. I don't know why that's going to help me, but I'm going to help. It's going to help me. My inner 7-year-old Linda is going to sleep with the light on tonight. Nate said someone sneezed, but that's so weird. If you guys heard it, it was so weird. That's funny. They creep me out. Question, who's being charged for Brandon's incident, the wife ex? So Brandon Boudreaux, his trial is coming in the beginning of June. Lori is charged with conspiring to kill Brandon Boudreaux. It is a wonder why, I guess they don't have enough, but it is a wonder why Melanie Boudreaux / Pulowski is not charged, because she was going to benefit from the $1 million as well. I think Brandon's was also $1 million. I'll have to review that. But I do have a Brandon Boudreaux series, just like I have a Charles Vallow series. So if you want to dig into that on the weekend, please dig into that. And we started the other day looking at the discrepancy video that I created. I think it was just over an hour long. We only got into 22 minutes. Will she have a Shih Tzu look? She might even pump it up. That was high yesterday. That was like, she teased the crap out of that one. I don't know. Kara says today should be a nothing burger, but you never know. You don't know. We just don't know what happens. So we might as well be here for it. There is going to be a court hearing, and I think it's going to be 12:15 my time. So in 10 minutes it should be. Susan J says Colby's video last night was heart-wrenching. He found out stuff for first time yesterday. I'm not sure what he found out. If you guys want to talk about that. Okay, you guys are getting into what what you guys think. What was the biggest part for you guys? The text messages. Janelle says when Lori had all those phones and did not dial 911 herself. That was awesome how they went through the timeline. And Trina, I love this where she's like, so at this point, at 12, whatever it was, had Lori called 911? No. I loved that part. That's probably one of my favorite parts. It's me says it took too long to call 911. Kay says the timeline. Margie says the texts. Sylvia says insurance and text. Bell says the text messages for sure. And Bella says the judge never said bless you. He's always done for sneeze. Aaron says the last testimony did it for me. KCL Adams' testimony sealed the deal for me. Let's talk about this for a minute. So we have Kay Woodcock, Charles's sister, and we have Adam Cox, Lori's brother. And both of them said, I knew it was her. I knew she did it. Basically is what the bottom line came out. And to get on that stand, both for Kay and both for Adam, I mean, that's huge. And Adam didn't give Lori an inch of wiggle room. He just went, yeah, no, I don't remember when I saw you. I don't remember. And she's like, you didn't try my green chili enchiladas, my green chili chicken enchiladas? No? So you don't remember my green chili chicken enchiladas? No, it's a non-chalada. Okay, Lori? No. But I do remember the murder of your children, and I remember the murder of your husband, and I remember the murder of your current husband's wife. So there's that. So they both really gave it to her and didn't let her get an inch. We learned though, which is another level of evil, that Lori took Charles's ashes, put it in through FedEx, and FedExed him to Kay Woodcock's workplace. I wish they would have got into more of her vindictive behavior. And maybe because we like a little bit more detail, maybe not even that, maybe just slower on the texts. Like I find the texts were like really fast. And maybe it needed to be emphasized to a degree. I don't know. But Lori messaged Charles's kids, like, by the way, your father's dead. I wish that more like manipulation, vindictive, and they did say some stuff. I'm just saying, I felt like that would have been, I don't know. Lori got away with a lot in this trial. I understand the judge has to give her opportunity, but she took all kinds of opportunity. So I kind of wish that Trina might have said something that would just like, not get in trouble, but just spill it a little bit. A little bit. Kate says the fact that it looks like she isn't going to present any defense. Lori got in trouble a little bit. I shouldn't say in trouble. The judge advised Lori, like, you were supposed to do this long time ago for the subpoenas, so it's too late. It's kind of too late now to do XYZ. It's too late. Okay. Kat says yesterday, the last 2 hours of the case. Kathy, not calling 911 when someone was shot. They waited 47 minutes. Nephi and got rid of. She tried so hard to because we got rid of was right in there. And then she tried to say, "Well, Nephi is in like 25 times. You don't know that? You know?" Oh, what is she gonna do in Brandon Boudreaux's case? Rochelle says, "Morning timeline sealed it for me." Amber Eyes says 47 minutes and the two shots fired on the ground combined with the text messages. The messages is what got her. If the jury didn't see before, I hope that opened her eyes. But yet they did talk about, well, they talked about affirmations of love, is what Trina called her. The messages, the loin fire was the affirmations of love. You sure that's what that was? The calls, Shenanigans says, the calls from Alex before he called 911 because he's patching in with Lori. He's calling Lori. No 911 call, but Alex is calling Lori. And also at 7 in the morning, Chad and Lori had 1 hour worth of text messages that were deleted and were not retrieved. Yeah, this is so good. Good point, Victoria. Victoria says, questioned her character when she was acting so high and mighty about affair and text proof she was actually having one. Clear she was projecting her crap on others. When she came out and was saying to Nancy Joe, so you always marry married men, or you always date married men? Or you always go on dates on married men? And then we had the beautiful part where Nancy Joe said, don't flatter yourself when they were talking about, Charles and Nancy Joe talking about Lori. So there was some pretty good moments in court, but she did look like an idiot doing that. She contradicts herself. Okay, here we go. Look at this. I'm gonna make sure everything's, yeah, sound is on. We're good. Okay, so we'll just wait till they start talking. This is great. Oh, Don says, I think Nate is wrong. I believe he said he didn't hear anything, but believes it was a sneeze. I don't know. Allie, you can go to yesterday's live stream and I play it over and over at the end of the live stream. I spent like 10 minutes maybe talking about it. Yes, I think Melanie should be charged as well. Hey, that's great. Says the higher the hair, the closer to God. Oh my God, when she was saying, did you open the apple juice because people get thirsty after their adrenaline goes up? Like, what? That's because she's trying to see if she's not going to cry. She doesn't cry after that. She's dehydrated. We'll see what happens this morning, but maybe Lori can lose it today. She's going to be there. She's been in court this morning. They had to figure some stuff out. I just wanted to see her lose it. Just to put that icing on top for the jury to see just how maniacal she can get or how vindictive and manipulative. Chanel says it was Lori's green chili chicken enchiladas that did it for me.
We're probably gonna need like 10 more minutes, that's okay?
Oh, 10 more minutes.
Well, I have some, did you get the state's email this morning?
We did, that's what
I have a couple revisions based on what they said, but also I need to, one thing I need you guys to address is, I did 404, 4.04, the justification, self-defense instruction, and on looking through the instructions again, I don't know if 4.05 is more appropriate, because that's the one that deals with deadly physical force.
It would be.
So why don't you guys talk about that? And yeah, I'll give you a few more minutes. We can, yeah, we're off the record.
All right, so we wait a little bit. Leslie says Kay was just brilliant. Yeah, she was great. And yeah, Lori's beyond terrible. Yeah, they had that this week. Elise said Kay called her out about pretending to have 5 kids to take care of. Charles' boys weren't living with them. That was a sweet moment. Because that's also in text. 5 kids, and you know, I don't get money for JJ, you know? And Kay gets it all. Charlotte says, no one came to speak well of her. That says a lot. It really does. Well, look at her. I mean, the things she was doing. How many people do you think when they were in there, the witnesses are looking at her, biting their tongue that they want to say? Because you saw a couple of the witnesses go, well, because we couldn't, or whatever. And you're wondering what they're thinking, like, yeah, because you murdered your children. All of a sudden, she's worried about Tylee. Okay, Lori. Oh, yeah, Sharon says, Linda, what about her saying, did you know Alex was a comedian and that he likes to joke? Like she's making up like, oh, this text exchange, it's all just about the joke. No, you're the joke. Crystal says, I grew up LDS, was in it for 40 years. No one thinks of any other Nephi than the one who killed Laban when he was referenced. And the detective said, I've asked numerous people and they always told me the same thing. Affirmations of the horn dog. Rich says timeline of messages did it for you. Cheek to cheek and loin to loin. What a line. The phenomenon, the scientific phenomenon known as the loin fire, and Chad's itty bitty storm. He's so gross. How's the basement now, Chad? The Nancy Joe we didn't know we needed. I know, too bad today isn't closing. It'll be Monday. It was almost going to be today. They talked about it, and then Trina's like, I'd really like it to be for Monday if the courts are good with that. They should be another 5 minutes, maybe. They had to wait another 10. They were talking something about deadly physical force. Let's get into it. I will definitely be covering Brandon's case. Absolutely. And then whatever other trials we could do will be streamed on here as well. I really, really enjoy going through these cases with the trials with you. It's one of my favorite things. Brenda says Colby was so upset about the things he learned yesterday. Rightly so. It doesn't stop for that kid. It just keeps going, you know? He's been through so much. How does even anyone be? It's hard enough just to even lose somebody naturally, let alone have his brother, his sister killed and egregiously, and his stepdad, and uh and his mom going into prison for it. It's like that's a huge thing on a young kid. Huge. Obviously, we know that, but you know, like imagine the trauma. I love this. Lori could not bully Kay. No. Janice says, did not get the notification today. That's terrible. I'm gonna do a quick message in the community tab, maybe. Let me think here. I need my link. Maybe I'll put that on in a minute too, so I can still talk to you guys. Do we know if they have text back and forth about Brandon's attempted murder? Yes, there's texts. I would do that in my Brandon Boudreau. Let me give you guys that. I have a Brandon Boudreau playlist. And Melanice in it too. So you guys have some fun info snacks and watching to do. It's right there. Oh yes, she wrote her last name is Lori Ryan on her marriage certificate. I wish they would have went, which husband is that? Number 3? Was that number 3 for the Ryan? Number 1, number 2, number 3, number 4, number 5? Nate said that Lori has a lot of people supporting her financially, buying her court clothes and putting money in her commissary. That shocks me. Yeah. But people do weird things. Oh, no Shih Tzu this morning. Oh, maybe there's a little bit. How is she dyeing her hair and streaking it? And she'd have gray hair. How's she dyeing it?
All right. We're on the record on CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As
Well-
of this morning, I mean.
Well, do you anticipate that changing?
No,
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. Let's just go through page by page. I think it's probably the easiest way to do it. On the cover page, I did correct, I had 2001 instead of 2021, and I corrected the case number. The first instruction at the top, page 2, duty of jury evidence to be considered and rulings of the court. These are standard instructions in Arizona. I'm assuming there's no objection to those from the state,
No objection.
from the defense?
on page 2,
Yes.
no objection.
All right. Then on page 3, I did remove the stipulations because I don't think there were any stipulations. So on page 3, direct and circumstantial evidence, production of witnesses and evidence, redacted exhibits, those are standard. Any objection to those from the state?
Your Honor, I did object to the production of witness and evidence.
I want to hear about that because that's a standard given when we have a situation where we've heard about people like JJ, Tylee, Alex Cox, we've heard about Summer, we've heard about Detective Moffett. None of those people were called at trial. So I think this instruction simply says that neither side is required to call, basically everyone that's mentioned in the evidence.
Yes, as long as the defendant is okay with it. Obviously, I've not seen that previously included in an instruction. My concern was the burden shifting potentially, saying that neither side is required. And that seems to imply or in opposition of the fact that the defendant need not present anyone anyways, ever. That's my concern with that instruction.
All right, before we talk about that one, let me hear from the defendant. Any objection to the direct and circumstantial evidence and then the redacted exhibits on that page?
No, those are fine. Your
Okay,
Honor.
what are your thoughts on the production of witnesses and evidence?
I tend to agree with the prosecutor, but
That it shouldn't be in there?
correct.
Well, if the parties are stipulating that it's not in there, I'll remove it. Is that the case?
I believe so, Your Honor.
Yes, Your Honor.
All right, by the stipulation of the parties, I'll remove that instruction. I probably should have brought my hard copy because you guys are working off a hard copy on my computer. This is kind of maybe paginate different. So now my next ones are indictment is not evidence, self-represented defendant. Any objection to those from the state,
No, Your Honor.
from the defense?
No.
All right, then on the comments are not evidence. The reason I highlighted that is it was to alert everyone that I did change the language in that a little bit because the defendant's self-represented. It mirrors what I did in the opening, what I read to the jury before opening statements, more or less, in changing it from the attorneys to the prosecutor and the defendant talk to you about the law and the evidence. Are there any objections to that instruction from the state,
Not as changed, no, Your Honor.
from the defendant?
No, it's good.
All right, then we have credibility of witnesses, and on my page 4 is testimony of law enforcement officers, but that might be on your page 5. Any objection to those two from the state
No, Your Honor.
defense?
No objection to the ones that are in there.
All right, then we have expert witness. Any objection to that from the state,
No, Your Honor.
from the defense?
Nope.
All right, based on the defendant's indication that she's not going to be presenting evidence, I would remove defendant's testimony. I would keep in defendant need not testify. And I would remove defendant witness prior conviction if that remains the case. So any objection to that from the state,
No, Your Honor.
from the defendant?
Nope, no objection.
All right.
Can we add in there something?
What's
Is this a
that?
time to ask to add something in there?
Go ahead.
The standard 19, the defendant statement voluntary.
Voluntariness of defendant's statements.
Mhm.
Uh, I- That probably should be in there. What's the state's position?
No objection.
I will add that. I'll add that right after defendant need not testify. Just making a note. All right, then we have jury not to consider penalty. Any objection to that from the state
No.
defense?
Nope.
All right, the state emailed this morning. I don't think the state, I think the state wants the alternative presumption of innocence, burden of proof in the Rajis. Is that correct?
Correct, Your Honor.
You want to make a record on that?
Your Honor, the current version the court has in here discusses the various levels of the burden of proof for preponderance and clear and convincing, which are not relevant to this. Case law is very clear under Portillo that the court is only required to present the Portillo instruction, which is partially on the next page in my hard copy, which explains to the jury the burden of proof for a criminal case. I think that going through other levels of burdens of proof without understanding or being provided context for that is confusing to the jury, is not necessary, and Portillo does not require it. So we're requesting the court just provide what has been mandated, which is the Portillo instruction.
What's the defendant's position?
We agree. It's confusing.
Okay. So I think that's just the last two paragraphs, right?
Yeah, from the three standards through the preponderance and the clear and convincing. So it would still have, the presumption of innocence, and then it would go to the beyond a reasonable doubts portion.
Okay, I will, by stipulation of the parties, change that instruction. So it'll read, the law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. Then I delete until the last two paragraphs. So then it will read, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The rest of that paragraph. And then the next paragraph, proof beyond a reasonable doubt is proof that leaves you firmly convinced, and that entire paragraph. Is that the agreement?
Yes, Your Honor.
Yes.
Okay. So my pages are not going to be the same as yours at this point. So we'll just go through it a couple at a time. Evidence of any kind, voluntary act, and then absence of other participant. Any objection to those three from the state?
Yes, Your Honor. And the evidence of any kind, I had sent in my email that we should remove acting with the advice of an attorney. Defendant is her own attorney, so she is, I think it should just be a period after evidence is left to the defendant, period.
You're right. I will remove that sentence. So what I would propose is it would read as follows. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. Is that what the state requests?
I would have left the decision on whether to produce any evidence is left to the defendant, period. And then the next sentence, cutting out acting with the advice of an attorney, and then have the last complete sentence as well.
I don't have a problem with that. What's the defendant's position?
I agree.
You agree with the state's
Yeah, I
wording?
agree with, yes, just to cut that part of the sentence off.
Okay. I already deleted it, so read it back to me, state, please.
Sure. So the state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant, period. Then the defendant's decision not to produce any evidence is not evidence of guilt.
So the decision on whether to produce any evidence is left to the defendant. Okay, when we're done, we're gonna print out another copy and make sure everyone's on the same page. All right, let me turn to the defendant. We've addressed evidence of any kind, any objection to voluntary act, and absence of other participants.
No objection.
All right, then we have motive. Any objection to that from the state?
We did have flight or concealment in the ones that we
I'm
have.
sorry, you're right. I should have stated, I did delete flight or
Okay.
concealment. I don't think it's applicable in this particular set of circumstances. So then we just have motive.
No objection to motive, Your Honor.
And from the defendant?
Yeah, no objection to motive. No objection.
All right, here's where mine's gonna change a little bit. I did, the charged offense, each instance where it says first degree murder, where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, I'm sorry, the definition of first degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state,
No, Your Honor.
from the defendant?
No, no objection to that.
All right, then where it's altered a little bit, so there was an accomplice based on liability, I'm sorry, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm gonna have to do is we're gonna print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant need those printed out to review? Because I have
I was
changed
going to
it.
ask for those to be added, so I
Okay.
did review them with my advisory council.
All right, I want to make sure though that you are literally on the same page with what's going to be read.
Yeah,
So,
I would like them to be printed so I can see them.
all right. We'll come back to that when we get you a hard copy. What I wanted to ask the parties was, I initially included the Raji 4.04 for self-defense justification. But in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here, so otherwise the jury has to try to implant deadly physical force throughout this entire instruction.
And I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
well, I was going to ask for that for 2.04A.
For what?
The 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a,
Yes.
hold on, let me bring them up. what's it called?
It's the Cashion. Is that what that is?
So.
I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of, or crime prevention,
Correct.
in addition to justification, deadly physical force.
Correct.
All right, those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises,
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing
correct,
on the
rather than
property.
being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person. I'm not going to give justification in defense of premises that requires that there be a criminal trespass. I think it's confusing to the jury also, if there's an argument that's made that he committed a criminal trespass because he was on the lease, he had authority to be there, and he was, even if he didn't have authority to be there, he was invited in to get his son.
In lieu of that, Your Honor, then we would ask to add 418, 4.19, defensive residential structure.
There's even text messages about him going over there, whatever. And she booked his hotel room. And she knew he was coming over that morning.
Record on 4.11, which is use of force in crime prevention.
Sorry, I was looking at 418 that defense just raised. Let me go back to 411.
Did anybody's ears perk up when you're like, there's no proof of telling them to leave? Like, or I wrote that down, but that almost came up and went, oh, hell no, hell no. She invited him into a saute. Like, what?
411, but my
So,
search is
uh,
not.
I'm going to hop back to 418. 418 is not applicable. 418 applies to home invasion type situations, and it talks about threatening or using deadly physical force. If the person against whom the physical force is threatened or used is in the process of unlawfully or forcefully entering or having unlawfully or forcefully entered a residential structure or occupied vehicle. So there's no indication that Charles forcefully entered the house. So I'm not inclined to give 418. Does the defense want to be heard further on that?
No, Your Honor.
And then was there another, you said after 418?
I just said 418 and 419. I guess that's the presumption of that.
So 419. That's applied to the residential structure, so that one wouldn't be applicable if 418 is not applicable.
Okay.
So I'm not going to give 419. Did the state look at 411 yet?
Just found it, sorry.
Also, on the assault, she never once said that she was assaulted or anybody was assaulted in that house. Kind of with the BS of the bat, but she looked pretty jovial to me. Sorry, neighbors.
Your Honor, I think probably given Carson and the allegations that the victim used a bat, we would have to give that as well as then the instruction for the crime that they are indicating they believe Charles was committing, as is required per the
Right. So you agree that 411 needs to be given? So that's my reading as well. So I will give 411, just so we're clear, I'm removing 404 self-defense justification. I'm adding in 405 self-defense justification, deadly physical force. I'm going to add in 406 defense of a third person. I'm going to add in 411 crime prevention. Okay, I think that brings us to the definitions. I removed deadly weapon. I think I had it in there initially because I thought it was in the justification statute, but closer read, it's not. So in the definitions that I have right now, I have intentionally with the intent to, and then intent may be inferred. Then I have knowingly, willfully, knew. And if the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proved the defendant acted intentionally. Then the next paragraph, a defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense, and the rest of that paragraph. Any objection to those from the state,
No, Your Honor.
from the defense?
No, Your Honor.
And then here is where I've inserted the traditional definition of accomplice because I deleted the completed act definition of accomplice. So this says accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following: 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Any objection to that from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Then I have a few more definitions: act, conduct, physical force, and a definition of deadly physical force. Any objection to those from the state?
You said something else I don't see in here, so sorry.
Act.
Act was a previous page, sorry.
I kind of did it in alphabetical order. So accomplice went in, then act. So act, conduct, physical force, deadly physical force.
No objection.
From the defense?
No objection.
While we're in the definitions section, I'm going to have to look at when we're adding crime prevention and defense of a third party, whether there's any additional language in there that would require additional definitions. But other than that, are there any other definitions the state's requesting that I didn't include?
Other than, obviously, the state hasn't looked at either of those, either new instructions requested by the defense to see if there's additional information. So I would have to look at that prior to approving these.
Okay. But other than that, you don't have any that come to mind?
Not off the top of my head, Your Honor.
All right. How about from the defendant?
No, Your Honor.
So then the rest of this is pretty standard. It's the jury 4-person and the closing instruction, and then I have a form of verdict. Any corrections, objections to any of those from the state?
Just the form of verdict, changing the one ST as well to first degree.
Okay. There's no, we don't need any interrogatory on dangerous, it's automatic, right?
It would not be automatic, I
It's
don't
not.
believe so, because it does not require the use of a weapon. So we would actually need to have a penalty phase to
Okay,
have that
so that-
determination.
That would be done in the second phase, if there's a second phase.
Correct.
Okay. Let me turn to the defense. Those last, first of all, any other definitions that you think need to be included that I didn't include?
Hold on 1 second. Your Honor, we had missed one that we wanted added was mistake of fact, 205. I'm sorry, I don't want to backtrack.
Oops.
Oh, now it's sorry? Okay.
The revised jury instructions from 2 years ago don't have a 205.
Sorry, it's 204. I apologize.
Causation, ignorance of fact, is that what you're talking about?
Correct.
2.0401A, ignorance or a mistaken belief as to a matter of fact does not relieve a person of criminal liability unless, one, the ignorance or a mistaken belief as to a matter of fact negates the culpable mental state required for a commission of the offense, or two, the ignorance or a mistaken belief as to the matter of fact establishes a defense of justification. So what's the mistake of fact that you think exists?
Your Honor, it's mostly the mistaken of fact that have been presented as evidence in this case, like one shot versus two shot, you were being attacked, you weren't being attacked. It's things that the state is proposing that I'm denying.
Well, you can deny those and you can argue that, but that's not really what is meant by a mistake of fact. It refers to a misunderstanding of the facts that would somehow negate any criminal liability. In other words, you'd have to be under a false belief about a fact. I think an example might be if someone's breaking into your home or someone's coming into your home, you thought it was a burglar and you shoot them and it turns out to be your spouse. That might be a mistake of fact. So a dispute as to what the facts are, what the facts mean, wouldn't warrant this instruction unless you have something else.
That was all. That was what I was thinking.
Okay. What I think I'm going to do is I have to go back to my office in the central courthouse. I have to edit this a little bit. I'll add in those instructions. If you guys can wait here, we'll get you a clean copy by noon. review that copy over the weekend, make sure there's no other additions, corrections, or mistakes. And then the procedure will be on Monday. When the jury comes in, I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions, and I'll read the final instructions, and we'll go right into the closing arguments.
Your Honor, then I asked too, I'd asked defense previously, there are officers who are under subpoena still, that they be released at this point.
That's fine, Your Honor.
All right. And well, anyone at this point can be released from your subpoenas. Is that correct?
That's correct.
Okay. I'm just trying to decide the best start time. I'm thinking read the instructions at about 11, break for lunch, and go into the openings early at 1, or you can start and have it broken up by lunch.
I would prefer the court's option of reading the instructions, going for an early lunch, and then not having my
All right.
closing.
I'll have my staff contact the jury and tell them to report at 11. And then we'll still meet here at 10:30, make sure everything is good on the instructions and the defendant's intentions to rest. And then I'll read the instructions before lunch. That may mean we break a few minutes early for lunch, but we'll have them come back at 1 and go into the closing arguments. All right, while we're here, I'm going to call the other case as well, CR 2022-001242. And the state is here, the defendant's here. I'm going to go ahead and set the official trial date to begin May 30th at 9:30 a.m. Actually, 10 a.m., May 30th at 10 a.m.
Your Honor, are we still meeting though the 29th to do strikes?
Yes, I'm going to get to that. I will set a final trial management conference to discuss the remote questionnaire and confirm we're all good to go for the second trial. For May 14 at 10 a.m.
And Your Honor, I will say okay for now. Obviously, we don't have the victim here and we didn't notify him of this hearing. So if that does not work for him, then I will ask to move that.
All right, for now, we're setting the final trial management conference, May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning, actually, about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple days ago. So the anticipated schedule for trial, let me confirm with the state. You think the second trial is similar in length to this trial?
I believe so.
So my proposed trial schedule that we talked about is going to be June 2nd, Monday through Friday, June 6th. We'll shore up those hours and where we're going to be physically located, because I don't know if we're going to be in the same courtroom or not. But tentative schedule, June 2nd through 6th, Monday through Friday, June 9th through 13th. Depending on how far we get, I may cancel that Friday the 13th, but I'll let you know at the start of the 9th or the 10th. And then I have to be dark the 16th through the 20th. And if we need June 23rd through 25th, I think that should be enough time. So that's what I'm going to screen through is those dates for the remote questionnaire.
Not the next June, you said June 23rd through the 26th, but not the 30th through the 3rd?
Yeah, and here's why I'm thinking that is you completed the state's case in this case in
It'll be,
7 trial days, 7.5 trial days, 8 trial days. And the 2nd through the 12th is already going to be 9 trial days. And then if something goes wrong, we still have the 23rd, 24th, and 25th. So that's going to be 12 trial days. And some of those trial days I can make longer depending on everyone's schedule. We might be able to start earlier.
all right, the state will ask that we screen them through July 3rd. I just think there is always things that happen, and I would much rather have a jury prepared to stay longer and have them end late than have a jury angry at us because we told them that they would be done on the 25th and something happens and they are not done on that date or they're deliberating later. So I would ask they be screened through July 3rd.
13. That would give us over twice as many trial days as we had in this trial.
We had screened these through the 15th, I thought, of June. So
What's that?
didn't we screen these jurors through the 15th of June? So
No, May.
May.
I'm sorry, of May. So
We screened for 6 weeks and we did it in 2.
I understand, but I guess I don't see that as twice as long as this screening.
We had 21 trial days scheduled in this first trial, and you did it in 7.
We had 28 days scheduled in the other one. In any case, that's all I'm asking, Your Honor. You can do as you wish. That's my proposal, just.
We can confirm it on the May 14th when we meet at the FTMC. I'm open to it. My hesitation is if we go all the way into the 3rd, I think we're going to run into losing a bunch of jurors who are going to go out of town for 4th of July, and they might be leaving on the 2nd or the 3rd. And I think we're going to lose a lot of jurors just based on that holiday where people go out of town. With that said, the current last day is May 11 on that trial. So as defendant, want to make a record because I am going to exclude time. I know you object to
I
the
do
exclusion
object
of
to,
time.
I object to not having it by May 11th, correct?
You want to,
What?
do you have anything further than that?
No, just that, yes, that I would like to have my speedy trial by May 11th.
All right. Well, we screened the first trial through May 15th. We can't do, you can't do, and the state can't do, and I can't do 2 trials at the same time. Additionally, the state indicated they need to make arrangements for out-of-state witnesses to come well in advance of the trial. There's scheduling issues for myself. I'm out part of the week of May 19th. I'm out and coming back early the week of May 26th to do jury selection. Additionally, I guess the delay is of minimal prejudice given the current sentences that you're serving. For all those reasons, the court will exclude time from May 11th. The new last day will be June 30th. All right, let me get these jury instructions, an up-to-date draft for everyone. Please stick around. I'll have my staff drop that off hopefully in the next 15 to 20 minutes. And then again, when you review those over the weekend, please alert staff through your advisory council or your paralegal if there's an issue, because we're gonna have those all printed out Monday morning if we don't hear from anyone by about 10 a.m. Again, we'll ask my staff to contact the jurors and have the jurors report for 11 a.m. on Monday.
And Judge, is the court able to just email those to me, or do you want me to stay here and wait to
I
get a
could-
hard copy?
I will email them to you and advisory council and the paralegal, but if you want, you want a
I'll
copy
wait for a hard copy.
yeah, I'll print out a hard copy for the defendant to take with her here today.
Thank you. Thank you, Your Honor.
All right. Are you signed up for that? Okay. All right, thank you.
Okay. Let's just see Lori for a minute. Come on. All right, so just to reiterate, they went through the court instruction or the jury instructions. They were amending a bunch of things. It's interesting, some of the things that Lori was bringing up, as always. And one of them was that crime was being prevented, which was a little back and forth. Hard to reiterate the details. Obviously, I can't write that fast. Hang on. Automatic play. And basically they were talking about there's no proof of telling Charles to leave that morning, that because she's bringing up that she was assaulted and he's not allowed to come in and whatever. You can't prove that. There's no proof, zero proof. So whatever. Anyways, they're adjusting all the jury instructions. That's fine. And the officers who were under subpoena are now allowed to be released. Probably because Lori's like, nah, if I get these guys up, and it's not looking good. I can't just talk about apple juice all day. What am I going to talk about? Officers, do you know what apps Charles was using in order to get a date? Do you know what he wore on the date? Did the girls see him in his bamboo shirt? Did they shoot him? Anyway, she drives me bonkers. Brandon's case is coming up. They gave a couple of court dates. I'll be following that. May 14, they're doing a management conference. We'll see if that shifts or not. It sounds like they do shift quite a bit, but they'll confirm all of that. Looks like May 30th is really when they want to get started at 10 a.m. And that's, I guess, would be the jury the questionnaire. 21st-ish, he wants to start the questionnaire. So the 29th, they're going to go through that remote questionnaire. And then the 30th, they get started. So jury selection. So May 30th. Now, he said for the actual trial, June 2nd, which is what we've heard for the last couple weeks. June 2nd, and it's going to be Monday to Friday this time. Trina said that she thinks it's going to last as long as this one. I don't know how. But if you remember, Brandon Boudreau had his attempt made on his life in October of 2019. So after Tylee and JJ were killed, before Tammy was killed. So it was the attempt on Brandon first in October. That's when we saw Alex and Chad. I think it was Alex first that got the seat. He pulled the seat out from the Jeep. He went to Arizona from Idaho, then came back, and Chad and Alex were doing the, the back of the Jeep tire kind of thing. One of them was Chad, one of them was Alex and Chad. Then the attempt was made on his life. Now, interestingly, we've said this before, check out my Brandon Boudreau playlist, because Melanie, then Boudreau, was split from Brandon, but she was the only one that knew the address, the new address, because Brandon had just moved. And so there was lots going on there. She lied. I put that also in video and did a discrepancy thing. And there was then back and forth between Lori, Melanie Boudreau, possibly even Melanie Gibb. I'll have to look that up again. And then Chad and Alex. So all of them were giving, were doing all that. Then there was Google searches about a shooting in Arizona. And might have even been, might have even been a death, but for sure it was like a shooting in Arizona. They were Googling it. Well, Brandon didn't get killed. It hit his head by missed his head by inches. So Chad wasn't charged. They feel like they didn't have enough on him, but they're nailing Lori, so to speak. So if Lori's trial on Charles was only 7.5 days, I mean, they're doing 5 days from Monday to Friday starting June 2nd. So I don't see how this is going to be that long. Like first week of June, second week of June, and possibly canceling the 13th, he said. And then from the 16th to the 20th, he has to be dark in the courtroom. So third week is canceled. Well, that's already 9 days. We don't know what Lori's going to do in that. We're told that she is also going to be representing herself. So who knows how that's going to go. But there's a difference too. Charles was dead. Brandon is not. So this will be interesting in here as well. But he said he's going to go up to the 30th. So the whole month of June, I don't see it happening. I really don't. But you never know. Maybe there's some more because now, Brandon's alive. So it's a little bit different, but Brandon didn't die either. So we'll see what happens and how many witnesses and all that. So we still have on this Monday, we have closing arguments. And what did I write down here? Lori's spicy because she wanted Brandon's trial to start May 11th. And she's been snarky about this for the last month. And there was a hearing on it. And he said, well, too bad. Like you're in prison and you can't do 2 trials at once. We heard that today as well. But I will be covering this case 100%. So we'll get that all started. I'll do some things beforehand now that I'm, diving in at 110% again. But I will balance. What else? Oh, I wanted to say this about Lori and her representing herself. Actually, I'll take some questions first and then I'll tell you. So hang tight. Lisa says this room is like the Cheers bar. I love it. Thank you, Linda. You're welcome. Thank you guys to be with me. I'm so happy to be with you guys. Okay, let me get to the bottom here, because I don't want to miss. Granny says, I just wanted to say thank you and I appreciate you giving us our time and loveliness. Much love, Linda. Thank you, Granny. Thanks so much for the super chat. I appreciate it. I love being with you. I really do, you guys. So Brandon's trial is going to start June 2nd will be the trial, but May 30th, from what the judge says today, is jury selection. So we'll be here for it, and I'll set that all up, and we get to hang out together. Now, when it comes to Lori representing herself, as she's sitting there today, acting like she's in charge, and really she's been like that all the past couple of weeks. I feel like she's acting like this is a bucket list item for her. Don't you? I feel like she's like, yep, this is what I'm supposed to do. This is a bucket list item and I'm going to do it and da-da-da. I mean, what do you think she'll reflect when she's sitting in her prison cell tonight, eating her bologna sandwiches? And even though she said she doesn't need to eat or drink, what do you think she will reflect on how she's done? Do you think she's proud of herself on this? Do you think she's like, oh, I should have said something else? What are your thoughts? Monday, court instructions and intentions to rest from the defense is at 10:30. So remember the half an hour. So we'll be back here at 12 Mountain, 11 Pacific. And then that would be 2 p.m. Eastern. Mama Moore says she truly has nothing to lose. She already serving life sentences, plural. Dawned on me says she'll talk to Jesus and Jesus will tell her she's doing well on her mission. Mel says self-critique is not in Lori's world. But I wonder what she was thinking. It's like, oh, you know what I should have done? I should have said to Nancy Joe. Chris says, I think she's sad she didn't start sooner. Oh, 1 p.m. Central Time? Or is that where we're at? Yeah, thank you. Ancient Teapot says I'm not a lawyer, but I play one on TV. Cindy says, oh, she thinks she's so important. We'll set up lawyer shop in Priding now. And imagine how big her head will be if she gets not guilty. Yeah, it does get her out of jail. Steph sells stuff by the seashore says, yes, but trying to prove a point for the other women in jail. She's probably going to give lawyer advice. I'm going to give law advice now. I'm going to start charging for it, and I'll charge for my low workouts. The loin fire workout, the cheek to cheek and loin to loin. Chubby Bubby will tell her she's doing good in the portal potty. I missed your question. Please repeat it. She's miffed she's not getting her speedy trial. Lori, her narcissistic and delusional ways thinks she nailed it. 7 p.m. in the UK or 8 p.m. I think you guys are 8 hours ahead. Yeah, she was. Yes. Lori, trust me, I'm almost a lawyer. Illegally blonde. Linda, could you ask if people think she was there for the shooting or not? What do you guys think? Do you think she was there for the shots? 1 shot? 2 shots? You think she did the second shot? Legally non-blonde. Both shots. Hell yes, she was there. I think she shot him. Yes. I said earlier this week, or maybe it was last week, that I had wondered if they knew the trajectory of what the height where the hand would be and what it would compare to Alex and Lori. That I find fascinating. Chubby hubby bubby. She said she was in the house when she heard the first shot. Yeah, she was probably staring right at him when it happened. There's no way. She's so malicious. And remember, it only happened in a couple of minutes, like very quickly. Any way you slice it, she's still Lori, and she still did what she did. It's too bad that the jurors couldn't know. I understand, but it's too bad that they couldn't know what she's done to her kids and what she's really capable of. Yeah, she's probably thinking, who will I marry in my next probation? Actually, if you guys go into my discrepancy video, and remember they were talking about, she said Tylee went back in to go get the purse but didn't see anything. That's a lie. Because I showed it when the camera came in. You go in to go get your purse. She said the purse was in the closet. I don't know many women, some do, but not many women have all their purses, their current purse that they're using in the closet. And so but that wasn't the discrepancy. It was if she went to go into the room, get the purse, and come out, it's in direct sight of Charles lying on the ground. So I remember doing that. And interestingly, I did that series, the Charles Vallow series, right after the kids were found. I believe I started a month after that and started digging into Charles and ripping through the discrepancies. Yeah, so there's a lot of crap that went on. So take a look at that if you guys still want to dive through the Charles Vallow or dip into the playlist of Brandon Boudreau because there's a lot of stuff there too. Why do you think, Linda, that Lori is so fixed on having her speedy trial in May? Well, that's her right, is to have a speedy trial. And her right is that May 11th is the deadline. But the judge already addressed it on a previous thing saying, well, look, I realize that's the date, but we can't do 2 trials at one time. Therefore, the closest I could do it is on June 2nd. Net Detective says, I think both kids saw what happened. And imagine that they went, well, just shut them up and get them some chicken fries and Sprite, shut them up and send them to school. Send JJ to school. Oh, well. What else was I going to show? I'd have to do that on Monday and I'll cue some things up. May 11th is someone's birthday. JJ's is in May, but I think, I don't want to get this wrong. May 25th, 2012. If you haven't seen my video on birthdays and death dates, you got to take a look at that. I was reverse engineering. I'm like, what's the pattern? And I was looking at the dates of when they were killed versus their birth dates, and they all had a pattern. So I think it was chosen for a reason. Peter says the video of the storage place will be the big in the Brandon case. You know, it is even funny of the moment that we get to see. Thank God, no loin fire. But we will see the tap at the butt that Chad made to Lori, taps her on the butt and like goes slides down and taps her, whatever the heck. That was part of the storage unit. And when it first came out, this storage unit of Alex carrying the seat, the Jeep seat, we were like, what is that? Because it was hard to see. And then Nate got better footage. But at first, it almost looked like a leg was hanging or whatever. But it was actually just the Jeep seat that they took it out. And then they took the Jeep tire off the back and then brought it back. EB, hey Lynn, it's great to see you. Great to see you too. Would you mind putting up a poll? If I knew how to do a poll, I'll do a poll in the community tab. How about that? And that way we can find out in a grander scale. Well, and maybe the algorithm will trigger some notifications for people because it's so frustrating not to have notifications go out. I don't know what else to do. I already last week had to talk to YouTube because there was something going on with my channel and in the background, like setting it up. And for some reason, I don't know what happened. So I messaged them if everything was duplicating. So I'm sure I got a hit on that for some reason. Where are all the videos at? Okay, I'll give you the Brandon Boudreau. So there's several playlists. You can go on my channel and see under playlists, but I have the most important videos in the Daybell case. That's one playlist. I have another one's a Charles Vallow series, and then I have another one like of all the videos. There's 30 videos in the most important videos on Lori and Chad to date. Let me just find you Brandon's. Yeah, Melanie Pulowski and Brandon Boudreau. And I'll go through it as well, maybe add some more things. Is May 11th Mother's Day? Wow. Now that makes sense. Why she's oh my. Look at you. Thanks, Robini. Doesn't surprise me, that idiot stick. Oh, well, welcome aboard, dawned on me. So I have hundreds of videos on the Daybell case. Like I've done, I think 667 videos, or maybe this is 69. I don't know. And there's hundreds of that in that case because I just followed it. Okay. Let me just write some things here. She is the devil. Lori's birthday is June 26th. It's the same day as Brandon Boudreau, only they are days apart. So I guess we'll be seeing Lori on her birthday and Brandon's birthday. Maybe. I think that's too long. A full month to do Brandon Boudreau and Charles's only took 8. Mm-mm. Aw. My wife and I missed you and loved having you back, but we understand how dark this place is. I'm better. I'm a lot better. I did take a lot of time, but it was weird because every time I tried to come back, something would happen. So I think it just made me realize how to do things differently, not to pull 16 hours a day just to, I don't know. I'm just learning how to do things differently and balancing and be able to create a life for myself outside of this rather than 5.5 years of grinding and uh, and it not work out. And mentally things happen, and then when things really happen, then I'm on the decline. So we don't want that. So I'm just, I guess, boundaries and all kinds of things. But I love being here. So we'll figure that out. Yes, 100% got to keep mind and body balanced. And speaking of, I've been doing workouts, so that's good, but I got to get myself to the gym. That's the next one. I've been doing them at home, but now it's time to go to the gym and work on that and just, balance and have some fun. I need to have some fun. I love that you guys are here. We are a family, aren't we? You seem healthier and happier. I was in it, you guys. Like when I think I did a video in September and then I was in it. There was a lot going on and I just went, that's it. That's it. I'm just going to do what I do. No income coming in. I shouldn't say no, barely any income coming in. But I just went, I got to take care of myself. If I don't take care of myself, something's going to happen. So that's what I did. But now I like being back and we'll do some more videos. I don't know what yet because now there's a couple weeks difference, right? I thought I was going to do trial till June 9th. I think it was. No, not June, May 9th. May 9th is what I thought, but now we're early. So I'm going to go through this stuff, reflect on some things, do a couple videos. We still have Monday to go, and we have Monday for the closing arguments, but we also have deliberation. So who knows? How long do you think it's going to take? Oh yes, I was going to get the birth date video. What did I call it? It was a premeditation video, but I also did the dates. Was that my September video? No, that was a different theory video. Let me get that for you guys. It's interesting what she did. I did the zombie origin video. Did you guys see that? It related to a painting. I can't remember if I did another video. This must be it. I have almost 700 videos, which is crazy. I know. I was in it. I was in a really rough time. Then I got sick. Then my friend died. You betcha. I'll be doing all that. Now I have some time to plan that, when it's all coming out. So I probably will go to a coffee shop and sit and hang out and write some videos that I need to plan out. And I really, really, really want to do some interviews as well. So I'll be focusing a little bit of that. I think it's fun. I think it's time for me to do that. I could talk a little bit of the Daybell case, but we could talk about other things too. I know. Maybe one day we'll all do a meetup. Wouldn't that be fun? I think that would be really fun. I love meeting people. I'm the type of person that I'm sure you guys can you can see this in me, I'm sure, because I'm a talker. But if I go somewhere, I'll talk to the server at a restaurant. I'll go and talk to anybody in the store, like whatever. Sometimes I think people think I'm crazy, but I don't know, it's fun. I'm okay with meeting people. I'm not scared to meet people. Victoria says the trial raised some questions for me on Lori's whole family and what they think, or if they were involved. It's so interesting because it's so intertwined. Oh, you did see the one in the painting. Yeah, it was interesting. Veruca says, Linda, just let me know when you want the verdict to come in. I'm always in a store at an appointment during every verdict watch. I'll take a drive and it'll happen. Didn't I do the painting video during Chad Tato's trial? We called him Chad Tato back then. I did it on October 1st. So no, it was after that. But I did one on the top 10 creepy less known facts before the Chad Daybell trial. And it started when he was a child. That was an interesting one because I pulled not so well known info. And I did Tylee and the raccoon vid because you know what's like I connected some dots to that, but it also bothers me that there's a missing bone from what they found at Tylee. Yes, I'll cover Corey Richins as soon as I find out when it is. I think it's stayed for now, right? Secret combinations video. That secret combinations video also talks about the Gadiantons. We heard just like one little thing this week about that. I'm going to ask Colby if he'd like to. I don't know if he'll take me up on it. I've been pretty harsh, not to him, but to Lori. So I would 110% invite him on, and I would be respectful. I wouldn't be hardcore on Lori. I would have him on 110%. I don't know if he would be on mine. I don't know. And I would have compassion for Colby, 1,000%. I seem the type to never meet a stranger. No, I meet a lot of strangers. That's why I know when there's a creepy one. Yes, that's hit for him though, right? So I'd be respectful. But there's some ideas. So if you can think of some people that you'd like me to invite, I welcome that. I have a list of my own and we could go from there. If you haven't seen the Josh um, um, Courtroom Confidential that I was on last week, that was a great time. He's going to come on to my channel and I'll have a couple people on and we'll just reconnect. And as for some others that were part of the trial or part of the case in the past, I'll do what I can to invite them on and we can go from there. I have asked Nate, so like I would love to have Nate on. Let's just hope that happens. I didn't mean that Colby is on his mom's side. I just meant I'm going to be respectful of it. You know? The Courtroom Confidential vid, yes. It's also in my community tab, so I'll grab that for you. That was a great time. I really liked being on there and chit-chatting. I miss it so much. I'll get it for you. Did you get that? That's the one with Josh. And let me just double check something here. Oh yes, it's Easter. I forgot about that this weekend too. Gigi says, I just couldn't believe she lawyered up herself. That's so weird to me. Well, it'll be interesting. Okay, queued up. So let me know what you guys would like, think. I need to get into part of that again, which is a little bit of a to redo videos again, having to edit and all that is a little bit it's a little bit intimidating right now because I just got back and I was kind of hoping till May 9th so I could ease my way back into this, but we'll do it. Oh, thank you. You love the sleeves. All right, you guys. Thank you for being with me today and all through this trial. We have another day on Monday. So I'm going to set that up. We'll do closing arguments and we'll see if Lori finally loses her composure. She has, but I just hope that it's going to be a big one. And then we have deliberations. So next week we're still here. So everybody stay put. And then we'll go from there. Okay. Love you very much. Thanks so much. And we'll see you on Monday. And possibly I'll add some things. We'll see. Bye.